Never in a million years have I ever felt as vulnerable and helpless, insecure, and sad as I was when the Department of Children and Family Services removed my child from our home for perceived allegations which were untrue. And then 5 months later, my child is removed from me. I didn't know what to do. I was stabbed in the heart, picked up the phone book, found the biggest ad, saw the law offices of Vincent W. Davis, and I called. And I immediately felt very comfortable. Gave me my options, told me what I could and could not do. And then I met Vincent Davis, and I was so impressed.
Good morning. Good morning. This is Attorney Vincent Davis. These are my office hours, and it's early on a Sunday morning, and I have a guest host this morning. I have Miss G with me this morning. And where is Miss G? She was on the screen there, and now she's gone. Miss G, are you there?
Sorry, I'm here.
Well, good morning. How are you?
I'm good. How are you? I had to get my coffee.
Always running late.
Story of your life.
So, I understand you have some questions for me this morning, Miss G.
I do.
Well, what questions do you have for me?
Okay. Why the CPS paper trail is so powerful in a case?
You mean the paper trail that they have against you, or the paper trail that you make for yourself?
Oh, the paper trail that you make for yourself.
Well, once the case starts against you, or CPS comes and starts investigating you, you want to make a paper trail to keep records of everything, to make sure that you're saving all of your evidence that you can share with your attorney who's going to be representing you. What I suggest to most people, and it's kind of elementary, but you'd be surprised people that don't do this. You know, go to Savon's or go to CVS and get one of those, spiral notebooks for $1, or get one of those folders and just start putting everything in the folder relating to this case, or writing down like a diary everything that relates to this case, because you're going to be surprised how it's going to help you and help your attorney in keeping track of things. The hardest thing in any case is called the marshaling of the facts, and that is organizing all of the facts and the evidence. It's not the law. It's organizing the evidence. So when you go to court, you'll have evidence to give to the judge. Now, an interesting thing happened just this past week. I think it was Friday. I went to do a hearing, and I told my client, hey, I want you to get as many letters as you can from people who know you talking about your character. And I did that knowing that there was a 50% chance that they would not be admitted. Well, we got maybe 6 letters. And they were letters from people in the community, letters from family members, letters from friends that just knew my client. And I submitted them. And interestingly enough, the county counsel, the prosecutor, didn't object. And the judge said, anybody object to these letters? And the judge looked right at the county counsel, and the county counsel was looking down at her computer screen, and she didn't say anything. And the judge said, again, does anybody object to these letters? County counsel didn't look up. And so the judge said, well, having heard no objection, these letters are admitted. And I believe that those letters helped me prevail that day in that case, because the court released the child to my client. So you got to keep that information together. You got to get that information. You got to keep it organized and present it to the court.
Thank
All
you for
right.
that.
Okay.
Yes. So what do you mean when you say CPS builds their case paper, uh, on paper before court even starts?
Oh, before court starts, they start gathering evidence. They don't file a case until they have investigated it and recorded things and gathered things and done interviews that they can prove a case against you. Remember, they're a governmental agency. They can't do anything unless they've made a record themselves. Sometimes the record may be true or not true. So they can't do anything until they have something to support their actions. That's just the nature of a governmental entity.
Well, so is the court really reading all these documentations, or is it just for show?
You know, I get the impression that most judges read all of this stuff. I really do, because sometimes I'm making arguments or other attorneys are making arguments, and the judge will reference something that they couldn't have known unless they read the documents. So, a lot of people think I don't think the judge reads this, but you'd be surprised. I think these judges are reading everything. You know, you know, it's one of these things. These judges are making decisions on people's lives, children's lives, and I think most judges today, there's a new generation of judges that is coming up, and hearing these cases, and I think that they are taking this very seriously. You know, the old picture of judges that you may have had in the past, it's different today. These judges aren't as old as you might think. They're a lot of women, a lot of minorities. I think these judges are very anxious to make the right decisions. And I've been tailoring a lot of my arguments, towards the law, because a lot of these judges are trying to make the decision based upon the law. So, yeah, I do think that they are trying to, and they do read a lot of the paperwork, despite what people think. I can't say during my whole 39-year career that was the case, but I'd say in the last few years, I'm getting the strong feeling that these judges are actually reading everything.
Okay. What is another question? What are the most dangerous documents CPS files that parents often don't realize are harming their own case?
Statements by relatives and friends and neighbors that don't like you, statements by doctors or nurses that you got in an argument with at the hospital, statements by teachers that you cussed out, and got in arguments with, those types of things. The people that you have gotten into arguments with or that don't like you for whatever reason are people that are going to come forward and try to bury you in these child abuse investigations.
Hmm. Um, what's in the paperwork and what to look for exactly for parents to kind of hear that from you?
I don't understand that question.
Um, what's in, we were talking about files, right? So what's in the paperwork and what to look for in the paperwork?
You mean the social worker's paperwork?
Yeah.
Well, I think you should review the social worker's paperwork, the reports carefully, ask for discovery from the social worker,
Mhm.
and something called the delivered service logs, and go over it carefully with yourself and your attorney to make sure that you know all of the facts. A lot of times, you get those delivered service logs, and there'll be something called exculpatory evidence in there that will actually help you.
Okay, Vincent, can you walk us through what's usually in a court report or petition?
Sure. In the petition, there are the allegations that are made against you. So there could be, and the allegations are divided up in the Welfare and Institutions Code. There are A allegations, B allegations, C allegations, J allegations. So the code is divided up into different types of allegations, from intentional physical abuse to accidental abuse to negligence to sexual abuse to emotional abuse to, real heinous abuse. And then in the petition, it's broken down by those sections where the allegations are made. Sometimes allegations are made and they cover more than one section. So, for example, if you physically abuse a child or allegedly physically abuse a child, it could be an A and a B, right? Or if you sexually abuse a child, it could be a D and a C, where it's a sexual abuse and an emotional abuse, okay? Or you could physically abuse a child so bad that you could get an A, which is physical abuse, but you could also get an E or an I, which is such heinous physical abuse that they'll want to never give you the child back. So that's how the petition is divided up. Now, just because the allegations are made against you by the social worker doesn't mean that they're true. You and your attorney have the right to have a trial to prove that they're not true.
Mm-hmm.
And, that's the subject of a whole different, office hours. But the report that accompanies that petition is called the detention report. And sometimes there's an additional report called the addendum report. And in those two reports, allegedly, are the facts that support the petition. Now, I'm going to tell you something that I've used several times recently. Sometimes these reports contain all of the facts which support those allegations. But one of the things these reports don't include a lot of times are the efforts of the social worker to give you services to prevent the detention of your child. And the social worker, at least in California, and I think it's like this in most states because it's a federal mandate, the social worker has to prove two things: that the abuse is true or the risk of abuse is true, and that they tried to give you services to alleviate the need to take your child. And I'd say 8 times out of 10, maybe 9 times out of 10, the social worker never addresses that. For example, the case I did on Saturday, the social worker wrote a thick report.
On Saturday?
On this last Friday.
Friday, yeah.
Wrote a report, but never addressed the alternatives. And all of the attorneys, the minor's attorney, the father's attorney, and myself, the mother's attorney, came up with, made that argument to the judge. Well, they didn't even try to make less restrictive alternatives. And we all gave the judge less restrictive alternatives, and the judge agreed and cited the law that they have to do this. So you gotta look at that paper very carefully. And if you say to the judge, "Hey, judge, look at the report. It doesn't contain any information about the less restrictive alternatives. You should be ruling in favor of returning these children."
Hey, Vincent, where's your face at? I had just got a text message saying they can't see you.
Really? My face is right on the screen. I can see you. Can you see me?
No.
Really?
Really?
I see myself.
That's weird. Okay. I don't see you. I don't see you.
Nobody else
I
is.
see you on the bottom, but I don't see you on the top.
Nobody else is saying that in the comments.
Oh, okay. I guess Betty sees you. Okay. Well, I don't see you. And somebody else texted me saying, I don't see Mr. Davis. Okay.
Nobody's putting that in the comments.
Okay. So my next question is, what kind of wording or phrase should parents be watching for in these reports?
I don't understand that question.
What kind of wording or phrases should parents be watching for in these reports against the parents?
That's a difficult question to answer. I guess it all depends upon the facts in the case and the evidence in the case.
Okay. All right. And if a parent reads something that's false or exaggerated, what can they do about it?
Well, the first thing they should do is highlight it, circle it in red, and discuss it with their attorney and provide witnesses that can prove, including themselves, that could testify to prove that statement is false,
Mm-hmm.
and documents to prove that statement is false.
Okay.
Why are you playing with the pictures, Miss G?
The truth is, and I hate to get you off track here, but I don't see you. Everybody else sees you, and one parent says they don't see you. So I know I'm not alone. One parent. I'm not saying a lot of you guys, but someone texted me saying they don't see you. I don't see you. I see a black screen.
Megan Wilson on Facebook says, "I see you."
I know I'm just saying I don't see you.
That's because you have that Obama internet.
Wait, here, I'll show you. Here, I just took a picture. Look,
I
check
know
this out.
you have that Obama internet going on
See?
over there.
See where my picture is? See where I am?
I believe you. I believe you.
I don't see you here. See that?
Right. You have that Obama phone and that Obama internet. So go to the next question.
iPhone. I don't have no Obama phone. Okay.
Oh, Betty Joe says, leave the stream and come back in.
Oh, okay.
Super Tamika says, I see you clear for the last 20 minutes.
I know,
but we've only been on the stream 17 minutes.
I know, but I showed you proof. I don't see you. So maybe remove and go back in. Hold on, let me see. And then
why do you remove me?
Well, okay.
All right. Miss G removed herself.
Oh, here you are. I see you now. See, I showed you proof earlier. Thank you for that. Whoever gave me that tip. See, you're off again.
Well, why don't we go on with the stream because everybody can see me except for you.
Okay.
You have any more questions?
Yes, I do. Turning CPS reports into your own evidence, right? That's one of the things you always talk about. How can a parent use what's in the CPS report to actually build a defense?
That's one of the things that's a lot of people overlook. Sometimes the usually reports intentionally or unintentionally sometimes contain evidence that can be used in your favor. And sometimes they omit things that can be used in your favor. And the omission of evidence is just one of the things that I mentioned that happened to me on Friday, where the social worker didn't put anything in the report about the less restrictive alternatives, right? But sometimes they put in things about statements that somebody makes or didn't make that can be used to disprove something. Let me give you an example. Sometimes in a report, they'll interview a witness and the witness will say, well, it happened ABC. And then they'll interview another witness on another page and they will say, no, it was BCD. And then they'll interview another witness who will say, no, it was CDE. So there are all kinds of conflicting statements by the witness, right?
Mm-hmm.
By the witnesses. So you can use that to show, to maybe support your client's statement that it was CDE. You get it?
Yes, I do.
Because there's a thing in when they teach you trial advocacy, no witness who sees the same accident sees the same thing or remembers the same thing when they go to court to testify. So how does the judge know who to believe? How does the judge know what really happened? Well, supposedly the judge is supposed to go by the preponderance or the weighing of the evidence. And if more witnesses say, no, judge, it was really CDE, then the judge probably shouldn't believe it was ABC. You get it?
I get it. Yeah.
Okay.
Should the parents be submitting their own paperwork or just waiting to respond to the CPS stuff?
That's a good question. That actually came up last night in the conversation I had with a client who wants to submit all of this evidence before the CPS report comes out or is published. And we're kind of, maybe not halfway, but maybe a third of the way through the case. And in this particular case, I told her, do not submit anything, number one, until I review it. And number two, let's not submit anything until we see the report. Because sometimes you submit evidence that takes you over here, but the report is addressing something over here. And if you start talking about something over here, you're opening up a whole can of worms.
Mm-hmm.
And you don't want to do that. So CPS has to publish a report. You don't. So what I like to do in most cases, not all, most cases, I like to wait until the report comes out. Then I address that. Okay. See, when you're being sued by CPS, you can wait and sit back and make them prove their case. And then you know how to form your defense. That's one of the luxuries of being sued by CPS. You don't have to prove anything. They have to prove it, and then you can defend against it. Don't jump the gun. Now, is that the rule in every case? No. But in the majority of the cases, it is. So what I don't want people to do is watch this and apply what I'm saying now to every case. Because I know a lot of these people are going to have cases that are much different. It's like, the general rule in California is character evidence isn't admissible.
Mm-hmm.
But there are 101 exceptions, right? So the general rule is to wait until you see the social worker's evidence. Then you produce your own evidence. But there's 101 exceptions.
Okay.
All right, go ahead.
What kind of documents do you tell your clients to gather that will contradict CPS's reports?
Any and all. School records, medical records, interviews from teachers, witnesses, relatives, neighbors, coaches, people, extracurricular activities, just anybody that might have come in contact with you or the child. The list is infinite. You really have to sit down and think about it. The other day I was telling someone, I need a list of 25 friends or relatives that might be able to take your kid. And their first reaction was, oh, I don't have any. And I said, wait a minute, you're 35 years old. Are you telling me you don't have any relatives? And they kind of looked at me and thought, oh, I do have relatives. And then I saw the look on their face that was like, well, I don't really want to sit down and take the time and make a list for you. But they didn't say that. But I've seen it many times. And so my response was, look, if you don't want to take the time to give me what I need to go into battle, don't expect to win this case. This is your case, not my case. And I don't know your relatives and I don't know your friends. This is your case. CPS is coming after you and your kids. Help me, help you. You're going to have to sit down and think about this. This is the most important case you'll ever be in your entire life. Put some thought into it with me. Okay? Next question.
If someone has a court hearing coming up, what's the first thing they should do with their CPS documents?
Put them in chronological order and give them to their attorney so that the attorney can review them, and then they should review them independently. And when the attorney has reviewed them and they have reviewed them, then they should be meeting together with their attorney in person, on the phone, on Zoom, and going over the documents together.
That's not going to happen if they have a court-appointed attorney. But anyways, let's move on. What's the biggest mistake parents make when trying to explain themselves in court without any paperwork?
Well, that's the mistake. Trying to explain something in court without any corroborating witnesses or documents. Because then the judge has to decide whether you're telling the truth or not. So if you can say ABC, but you can get another 2 or 3 witnesses to say, yeah, ABC is true, or you can get some medical records or school records or some kind of record to say, yeah, ABC is true, then, it's pretty clear cut that the judge is going to say, oh yeah, ABC is true.
Gotcha.
You get it?
Mm-hmm.
Okay.
So, Vincent, if someone is watching right now and feels like the paperwork is stacked against them, what's the next move?
If they feel that the paperwork is stacked against them, what's the next move?
Yeah.
Get a good attorney. Stay calm. Don't give up, that's for sure, but stay calm and realize this is just the beginning. Take the next step. Every day, take the next step forward. But you got to start with a good attorney.
I agree. There's a lot of questions on here and, questions from parents right now as we speak that should be answered. So would you like to answer these questions or would you like to answer them on another show tomorrow morning?
We can answer some now. I mean, this show is every morning, Miss G, at 6:30. I don't know if you can join us. It's kind of early for you.
Okay. So there are questions here. Here it is. Here's one question. The first one, Megan. Is there ever a point when it becomes a harassment charge against CPS? If they've been after you for the last 9 years, over 15 cases, not getting any new or different results from each search into my life. Yeah.
Well, 15 cases over 9 years. I would say that's harassment. And I don't know what state you are, Megan, but if you're in California, you should give me a call. You see the number at the bottom of this screen? That I would say is harassment.
That is definitely harassment, Megan. Risen Rare Gem said, how can you trust anyone except your lawyer if you have past history?
I don't know that you can. That's such a individualized question, right? Some people can trust their parents. Some people can't. Some people can trust their brother. Some people can't. It just depends, right?
Yep. Okay, so Betty Joe. Hi, Betty, and thank you for the advice earlier. What happens when a caseworker lies up on oath about an ICPC?
I don't understand that question.
Me neither.
It
Betty,
says, what happens when the caseworker lies up on oath about an ICPC? Well, if you prove that the caseworker is lying on the ICPC, you can report her to the Department of Justice and you can report her to the Department of Health and Human Services, both which are U.S. federal agencies, and they'll open up an investigation, a federal investigation that could result in that social worker being criminally prosecuted. And if you find a civil rights lawyer, that social worker can be sued, and so can the social workers agency, whether it's county or state, wherever you're located.
okay, thank you. Um, oops, sorry. Okay. So Margaret King said, "Hi, Margaret. Good. Good morning. In a lawsuit, question: Is the police included? Question. Besides suing CPS, who are other individuals that may be included in the lawsuit?
Well, it depends on what stage, but you know, the old school civil rights lawsuits always included always included the police. Um, as strategies developed and refined, sometimes they would leave the police out. And there's a lot of different strategies and reasons for that. Because a lot of times the police were acting and they were standing behind the social workers. So you see, there's a law that if the social workers come to the police and say blah blah blah, the police are supposed to, act for the social workers. There are some laws that say, well, the social workers have to tell them something that's valid or have a court order. Now, in some situations, the social workers don't tell them something that's valid and don't have a court order, but
Right.
they always try to hide behind the social worker. And sometimes when you're trying to get, a bullseye on a case, you don't need all of that extracurricular stuff because if you say you sue a social worker and the police, that doesn't increase the amount of damages you get. Say you're going to get $1 million. But you're not going to get $2 million because you sued the social worker and the police. You're still going to get that $1 million, but to get that $1 million, now you have to fight the social worker's attorney and you have to fight the police's attorney because they're being defended by different people, right? So if you can just get the $1 million and you just get it from the social worker's attorney, okay, it's an easier, kind of thing. And you see the strategy behind that. So
Yes, I do.
why sue the police when you can get the money from the social worker, and then you don't have to deal with the police saying, pointing the finger at the social worker. You get it?
I get it. It's really the
Okay.
social worker that, yeah.
Okay.
Okay. Betty also asked, is it legally by law, if you are approved by an ICPC, they have to put the child with the approved ICPC?
Yeah, kind of. So somebody asked, what is an ICPC? I saw that in the comments. ICPC is something called the Interstate Compact for the Placement of Children. So let's say this. We have a child in a family in Los Angeles, California, but grandma lives in Miami, Florida. Okay, and grandma wants a kid. Before they can place the child with the kid, supposedly an ICPC has to be performed. And I say supposedly because if you read Article 8 of the ICPC, it actually says that ICPC doesn't apply, but that's a whole nother story. But Florida has to go out and check grandma, see if grandma is okay.
Mhm.
So assuming Florida says, oh yeah, we went out and checked grandma, she's fine, place the kid there. When the report comes back to LA, 9 times out of 10, the judge will place the child with grandma. Sometimes when the report comes back, the social worker on the case will come up with, 101 reasons why they shouldn't place the kid with grandma. And sometimes the reason will be, well, the ICPC took so long that the kid has bonded psychologically and emotionally and physically with the foster parents. So we shouldn't send the kid to grandma. These ICPCs can take months sometimes. And I mean like 6, 7, 8, 9 months. And the reason why they can take so long is because Florida, who's doing this courtesy ICPC, don't get paid that much money to do this. So, Miami is not really, it's not on the front burner for them. It's like, okay, whenever we get to it. So it takes a long time. So if you ever have an ICPC issue, always ask the judge to order an expedited ICPC. There is such a thing in the law. An expedited ICPC has to be done in 30 days. Must be done within 30 days. So the social worker in LA has to do the paperwork right now and send it to Miami. The social worker in Miami says, oh my God, a week has gone by. I got 3 weeks to do this report and get it back to the LA. See, what happens generally is that the judge will order ICPC. It might be a month, 6 weeks before the LA social worker gets the paperwork done. So it's slowed down at every process, at every, stop along the way. So ask for the expedited ICPC.
Thank you for that. That's important. Super Tamika asked, if DCS doesn't have evidence like police report and forensic interview, what happens?
Say that again.
If CPS doesn't have evidence like police report and forensic interview, what happens? If they don't have evidence and forensic interview.
It depends. They make shit up. What do you mean what happens? They might have other evidence, right? They don't need police evidence or forensic evidence to prove a case. If they have that evidence against you, it's stronger for them, but they don't need it. They might have just statements of the kid. They might just have, one person that, lived down the street that said they allegedly saw something.
But that's hearsay, right?
No. Hearsay is an out-of-court statement used to prove the truth of the matter therein. But if I saw something that happened, I'm a percipient witness. That's not hearsay. It's not an out-of-court statement.
No, I get that. But what I'm saying is somebody can also lie about what they saw.
Yeah, but that's not hearsay. And people lie all the time about what they saw or didn't see. And sometimes the lie isn't intentional because you remember I said 4 people that saw the traffic accident at the intersection, they all saw something different. That's actually scientific. 4 people see an accident at the same time, and then you bring them into court. Chances are, I think it was an 85% chance that each of them will tell you a different story. They're not lying. They really believe what they saw, and they all saw 4 different things. You get it? Because that's how the human mind works.
Yeah, unfortunately. Megan Wilson said, Mr. Davis, is there ever a point when you can sue for harassment if you have been constantly had cases for the last, I think you already answered that earlier.
Yeah, Megan, you can sue anytime you want. The question is, can you win? And that's where you got to find a lawyer, get a consultation before you sue.
Megan also said, I never get to see a report when they have made allegations against me. She never. A lot of people say that, by the way.
Megan, that's a problem. You need to talk to your attorney about that. You
Mhm.
should be seeing reports. If it's not the first hearing, you should be seeing reports in most cases 5 to 10 days before the hearing. Right?
Okay. Betty Jo asked, what happens if there's a court order that they don't follow through with? That's a
You
good
should
question, actually, Betty. I like that.
you should talk to your attorney about filing a motion for contempt. Because if you didn't follow through on a court order, they'd make you pay. So make them pay when they don't follow court orders.
The social workers, right?
Yeah. If the judge makes an order and the parent doesn't follow through on it, believe me, you will be punished in some form. When the social worker doesn't follow through on the judge's order, it's like, who cares? You got to hold them accountable, just like they hold you accountable. And that's between you and your attorney.
That's sad. Good morning, Akima. So good to see you, honey.
Good morning, Akima. I saw one of your comments. I'll come on your show. Text me later.
I think we have to pay. I don't know what Super Tamika said. I think we have to pay for response. I think she meant that for you. Or do you have to pay for you to respond to people? I don't know what that means. Okay. Risen where, yeah, we saw your question. Akima said, so Akima Richard says, so what if a witness's testimony changes after they violate your rights consisting of due process and civil rights violation? That's a good question, Akima.
What if a witness changes their testimony?
Changes after they violate your rights, yeah. Consisting, oops. Oh, me. After they violate your rights consisting of due process and civil rights violation.
Witnesses change their testimony all the time. I mean, it's up to you and your attorney to show the judge that the witness's testimony has changed and that witness is not credible and that witness should not be believed. That's the only thing you can do.
Okay. Megan, you answered her question earlier. Megan Wilson's added, I have come up with all that paperwork and more, and they always say hearsay. It's hearsay. So you mentioned earlier, Attorney Davis, that how to accumulate evidence, paperwork, whatever. But they keep telling her, CPS courts keep telling her it's hearsay.
When you say they, who are you referring to?
CPS court, or the system.
No. The court is a building. The system is a lot of people.
Worker, attorney.
Who? Okay. So unless the judge says it is hearsay, it's not hearsay. So you got to tell me who. When you tell me they, system, that means nothing to me.
Yeah, I had to learn that the hard way too. I've been with you for like 13 years, and
Who is saying that? Who is saying that? Megan, maybe we should have a discussion about hearsay. Okay.
Oh Lord, don't go there. You already had it with me several times.
Megan, I took a evidence course after law school. And, the course was a total of about maybe 80 hours. About 25 of those hours was on hearsay by itself. So if you think you understand hearsay, you don't. So don't use that word, loosely. It's very technical. What your problem is that when you have documents, you and your attorney probably haven't figured out how to get them into evidence. And the reason you haven't figured out, and I don't know what the reason is, but the easiest way to keep a document out of court is to say it's hearsay. But if you remember earlier in the show, I've told you when there's a general rule that the document is, for example, a document is hearsay, there's 101 exceptions to that rule.
Mm-hmm.
You got to find, or your attorney has to find the right exception to put that document into evidence.
Yeah.
Because I can assure you that there's an exception. You just have to state the right exception. You know, a funny thing happened on Friday when I was in that court hearing. I said something, and the prosecuting attorney goes, "Objection, hearsay." The judge looks at me like, "Oh, she's right." And immediately I said, it is hearsay, Your Honor, but there's the exception. It's an admission against interest.
Whoa.
The
What is that?
courtroom went silent. And the judge said, I think the judge said overruled. In other words, my evidence gets to come in because there's an exception. I knew the exception. Okay? If I don't know the exception, my evidence is kicked out. So you got to know the 101 exceptions. Megan, I hope you understand what I'm saying. You see, and I tell this to Miss G all the time. Look, everyone knows the general law about CPS court, about these cases. That's in California in the Welfare and Institutions Code. And to be honest with you, most attorneys have a general knowledge of the law. They don't have an expert knowledge, but they have a general knowledge of the law. What most attorneys don't have is an expert knowledge of the evidence laws. They have a general knowledge, but they don't have an expert knowledge. I know a guy, I don't know if he's still alive, but he became famous because he was an expert at the California Evidence Code. And the way he became famous was he read the California Evidence Code, I think at least once every year. You know, that was tantamount to like Kobe Bryant shooting the basketball 2,500 times a day. I mean, he just did it over and over, and he became an expert at it. So you got to know you got to know the evidence code.
Gotcha. So Brittany has a long, I'm going to read it to you. What would I or should I do if I hadn't had jurisdiction hearing in the overextended days, 200 plus? Then 1 minute county council is asking for a continuance because they have neglected to find evidence. And then next thing you know, they're claiming that there was jurisdiction found back in March. They send my case to a different county, have put together that county send it back. Then they say they got jurisdiction for a second time, found me guilty due to CPS reports, no evidence, no nothing, just, and that's it.
Okay, I'm sorry to say I don't understand that question.
I'm so sorry, Brittany. McCarrick, maybe rephrase it. Margaret King said, the person that made the false accusation initially should be included in the cross-examination, at least in my case. She should be crossing examined. I don't think that's a question. What if they constantly drag out? Oh, here we go. Okay, so Akima said, what if they constantly drag out the court dates and reunification has been stopped for over a year? That's a good question too, Akima.
I don't understand that question.
What if they constantly drag out the court dates, like you know how they get a continuance always,
What do you mean, what if? So they drag out the court dates.
and then
Mhm.
reunification has been stopped for over a
Okay.
year?
Okay. And what's the question?
What happens then?
Nothing.
Okay. Betty asks, what happens if there's a court order stating that child is supposed to be placed with family with an ICPC? What can you do?
You get a lawyer and then try to enforce the ICPC.
Okay, thank you for that. Akima Richards said, I was told by the judge, although the most recent court order stated when my visits were intact, that the fourth parent and CPS neglecting my children's medical needs. Okay. Okay. Tanya Kelly's, okay, no.
Wait, hold on.
Are we
First
going
of
back
all,
to
hold on a second. Hold on. You know how I tell you sometimes you ask me or you say something to me and only you know what you're saying in your head. You're not communicating the thought to me. You know how I
Yeah,
tell you that sometimes?
yeah,
Now, when you're reading these questions, now do you know what I'm talking about?
I do.
These people that are asking these questions, they know what they're talking about, but they're not putting it down here in the comment section because they're rushing and they think we're going to end the show pretty soon and they're not going to get their question in, right? But now you're trying to ask that question for them, and you were thinking, okay, this doesn't make sense. I see it on your face. Now, think how I feel when you're talking to me, or we're on the phone, or you're texting me something.
Hey, Akima, I think Davis said earlier you can, baby girl. She wants to come on the show tomorrow and ask some questions.
Fine, that'll be fine. Tell Grace, Akima, email Grace and tell her to send you the link, and you can just come on with me or with me and GT. Whatever you guys want to do.
Yeah, that's fine. I mean, okay, so Megan said something that Megan Wilson, and that I get a lot every day, Vincent, and I haven't had a chance to speak to you about this, but she pretty much asked you. She's pretty much writing what I wanted to ask you. She's in Delaware. She talked to so many attorneys that no lawyer in Delaware and other states that will take on CPS cases. And I've been told by several parents from different states that the attorneys said they don't want to lose their license going against CPS.
Okay, is that a question?
Yeah. So what happens when you can't find an attorney and they all tell you the same thing, that they will lose their license if they go up against CPS? So basically, we all know it's corrupt and they're afraid to lose their license. What should you do? As a parent, what should you do if you can't hire an attorney from out of state?
I don't think there's anything you can do.
Megan Lawson, I am so sorry, my love.
But I don't think, I mean, I would guess that maybe she hasn't called enough attorneys. The other day I was talking to someone. I said, well, how many attorneys have you called? She said, I can't find anybody. I said, how many attorneys you called? 8. I said, call me back when you've tried 100. When people tell you, no, I can't help you, it's a difficult thing. But and yet, if you hear it 3 times, 5 times, 8 times, I get it. It's difficult. It's a hopeless situation. That's what you feel. But you can't give up. You got to keep calling.
This is so sad. Akima, you have some questions, honey, but we can answer them tomorrow, God willing, when you're on a show. So, Christina said, CN cop can cop be sued when boy told him in a car, "Dad raped me. He's now 38." I guess she wants to know if someone at 38 can sue.
It depends on what state you're in, right? The statute of limitations is different in every state. I know in California they've extended the time to sue a couple of times over the years, and depending on the facts and circumstances, he may be able to sue. He should be interviewed and talk to a personal injury attorney to see if that statute of limitations has run or not, or if it can be extended for whatever reason.
Okay. Risen Rare Gem said, if is no trust, and in the past you gave a list of 10 relatives, and in court CPS says you didn't, and you also give the list of the judge himself. So basically, I understand that question. You know
You
how
do? You understand that question?
yeah.
Okay.
So when you say to give 10, a list of 10 people or
I
more,
never said 10.
25,
I never said 10.
25,
There you go.
25 people or more, right? Of relatives or friends.
That's
And
per parent. That's per parent.
per parent, right? And the CPS says you didn't. You gave them the paper, and then they say in court that they didn't. The parent didn't give them anything, and then you also give the list to the judge himself, meaning you filed it in court for the judge himself, and the judge still denies it that he received it or she received it. What step can a parent take after that?
Okay. Number one, I guarantee you didn't give it to the judge himself. The best thing you would have done is give it to the clerk. That's number one. Now, when you gave it, and I guarantee you didn't give it to the clerk. Probably your attorney gave it to the clerk. Now, unless you saw that happen, and unless you have a conformed copy to prove you gave it to the clerk, it didn't happen. That's the reality of the courtroom. You know, Ms. G, I tell you all the time, the courtroom is a false reality.
Yep.
Up is down and down is up. Now, you can be frustrated all you want, but until you accept that reality or that false reality, you will never win. Now, do you want to win or do you want to be right?
When?
Okay. So the answer to your question is you should always come up with 25 relatives, and it should always be emailed to the social worker and to your attorney. Emails last forever. There's a record of emails. Social worker will be hard pressed to say she never received it. Anything filed with the clerk, you should receive a conform stamped copy as your receipt that you filed it. So then you can show the judge the receipt. If you have a receipt, the judge will say, let's find that copy. If you don't have a receipt, you are SOL. Now, your question was, Ms. G, what does she do? File it again. Send it again. Now, what I'm wondering is why that hasn't been done. If the worker says, I didn't get it. And you know she's lying. And the judge says, well, I don't have it. It must have gotten lost between the clerk and the judge, or the clerk downstairs and the judge. Fix it. Fix it.
I don't trust anyone.
You gotta fix it.
If
You know,
if you have the right attorney, let's just make that very clear.
no. That's common sense. Look, I tried to file something in a Northern California court for 2 weeks. 2 weeks. File something. The last thing I did was I hired someone in that city to go personally to the clerk's office. And if that didn't work, the next thing I was going to have to do was fly up there myself. Luckily, I got it resolved. But you keep doing it until it's done.
Okay.
I mean, doesn't that seem like common sense to you?
Yeah, I understand.
The social worker lies and says, I never get it. Okay. Here it is. I emailed it to you. Here it is. I sent it to you Federal Express. Here it is. I faxed it to you. Here it is. I sent it to you overnight mail. You keep doing it. If they say if I say I never got it, that's not the end of the story. You know, you sue them later for lying, but let's get it right. You got to send the relatives in so they can place the kids with the relatives.
Not just relatives, friends too.
Yeah. But assume they're going to lie. Just assume it. Don't be shocked.
They lie 99.9% of the time.
Okay, and now what are you going to do? You going to come on my show and cry about it? Fix it. You know, I want to tell you something that somebody told me in maybe 1979, 1980. She told me, she said, Davis, you have to do everything 3 times better than the guy next to you. You know what I didn't say? I didn't say why. I said, okay. I didn't cry about it. I didn't say, oh, life's unfair. I said, okay. I'll do it 3 times better than the guy next to me.
Yep.
Okay.
Okay, so now I know I told you save your questions for tomorrow to answer, but this one gets to me in my heart because touches me in my heart. Let me tell you why. Because I believe everyone should have a Ring camera at home and record the social workers. Okay. There's a Lexi case, New York. Lexi case, you guys should really look at it, read it, and understand it. It's very important to record the social workers. Akima said, can you use audio conversations between you and your children as evidence?
That varies from state to state, Akima. So Akima's in New York. So that varies from state to state. If you were in California, unless the child or the child's attorney knew that you were recording the child and the case was ongoing, the answer would probably be no. Now, the area of using recording and surreptitious recordings where people don't know they're being recorded is very murky. Very murky. So I would have to guess in California the answer would be no, but I'd have to do some, legal research on it.
In New York, you can.
I don't know. I'm not in New York.
Like I said, I need people to really look into the Lexi case. there was an attorney, Michael was talking about it the other day, and he actually won that case. And the social workers, when they go to your home and you have Ring cameras and they demand that you know turn it off and you wouldn't, and then they go to the court and they demand or they request several times, I mean, they don't stop to get an order for the parent to turn off their camera. But once they walk into your home, you can keep on your camera. It's like they don't
Yes.
want
No, no,
anything.
yeah, that's the law everywhere. If
Hmm.
they know you have a video camera
Hmm.
and and your home is your castle, right?
That's right.
If they know you have a Ring camera or that you have video recording,
Hmm.
they can't make you turn it off. And if they knowingly walk into your home and they know you have videos on and they don't agree to be videotaped, but they know it's running, then it can be used against them. They're stupid enough to stay and be videotaped.
They're stupid regardless. Ignorant. They're ignorant. Record their asses. Okay, just keep recording. I mean, a social worker, the only reason a social worker demands or requests from the court several times, when you guys gotta read the Lexi case, it's very important. They will not stop until they get an order for you to shut down your camera. Okay, and there is a reason for that, because they don't want to be caught. They don't want to be caught because they lie. They lie in their reports, as many of you already know this. Okay, Akima, thank you for bringing that up. Super Tamika said, this is important to Attorney Davis. Her grandson got broken arms and had to have emergency surgery in DCF custody. I'm in DCS custody. And he told her exactly what happened, but it doesn't match the report that the grandmother requested from CPS at all. Meaning CPS hides the information, right? They'll say the boy was playing around and he fell. But if that parent had that happen in their custody, then they will remove the baby. I mean, the child. But she's saying it doesn't match at all. What the boy told her doesn't match what's written in the report. What should she do next?
Do you know what state or county she's in?
I can't remember. I know I can't remember. Tamika, if I mean Super Tamika, if you can just write it down, that'd be really helpful. I don't know.
Okay. So number one, she should do all of these things, in my opinion. She should get an attorney, discuss it with that attorney. Number two, she should report it to the Department of Health and Human Services. Number two, she should report it to the U.S. Department of Justice Civil Rights Division. And of course, the first thing I said was to get an attorney, to have this investigated, and to file the appropriate claims if necessary. Unfortunately, I've heard this story many times.
Mm.
And the reason why the story doesn't match exactly what has happened is because the social worker doesn't want this to be sued or doesn't want the county or state to be sued. They don't care what happened to your grandson.
Nope.
They just don't want to be sued.
Nope. Mm. Okay. That's a good question too, Akim. I'm going to have to address that one. Who do you go to when CPS assigns a therapist for mental health treatment without a court order or your consent?
You go to your attorney. First of all, CPS, at least in California, Akima, CPS can't make you do something if the court hasn't ordered it. They can suggest, but unless the judge has ordered it, you don't have to do it. Now, if the judge has made an order that says do whatever CPS says, in my humble opinion, at least in California, that would be an improper order that you should challenge or appeal. Right? They don't get to decide everything in the case. That's the judge's decision. They get to make recommendations, but they don't get to decide what the orders or what you should be doing. They're not experts. Right?
Mm-hmm. Okay, Brittany said, instead of answering my questions, my lawyer explained the chain of government funding down to CPS. I've heard that before, Brittany. And explain case quota. So he says you have no money, so you play their game and big and big. Am I done fighting? What the F? Okay. So I've heard that before, Attorney Davis. Like, what if their attorney says something like that to them, to the parent, right? Should she pretty much report that attorney, or what should she do?
I don't know why you would report the attorney. He's just being honest. But
Being
what,
honest and showing results are two different things. Okay.
it goes back to this expectation, Miss G. Maybe you haven't been on the show or you haven't heard me say this. When people get court-appointed attorneys, they're expecting to get Johnny Cochran.
Oh,
That's not what the law. That's not what the law says.
Mhm.
You don't get Johnny Cochran, and you shouldn't expect to get Johnny Cochran. You get a warm body that generally knows the law. That's what you are entitled to. Now, this court-appointed attorney is just giving you his opinion about what should be done. What are you going to report him for? He's giving you his opinion about what should be done. Now, is that my opinion? No.
You know what? Oftentimes the court-appointed attorneys tell them that, and then they don't submit any evidence into court. So
Okay.
how is she going to beg? What is she begging for exactly? For her child? He said you have to beg.
Miss G, out of 100 different strategies, that's a strategy, believe it or not. You may not like it, and I get it, but it's a strategy. It's not Johnny Cochran's strategy, but it's a strategy.
Yeah. Okay, so Margaret King said, Mr. Davis.
No. This is very important. You have to understand this because you're just blowing it over, and you really don't understand what I'm saying.
No.
Yeah. I think you understand it. I think you just don't like it. If you lay out on a table all of the strategies that a lawyer can give you, one of the strategies is, listen, do whatever the social worker says. That is a strategy. It may not be the strategy you want to hear, but it is a strategy.
I get it. I get that part, right?
Okay. And that's all you're entitled to is that guy or gal's strategy.
Yeah.
Now, if you wanted a Johnny Cochran strategy, you're not entitled to that from a court-appointed attorney. Do you understand that?
Mm-hmm.
You do? Okay. Well, if you want Johnny Cochran strategy, you better go out and hire Johnny Cochran.
He's dead.
Well, you better go hire the next best thing.
That's you.
Okay.
Margaret.
You know what? I was out last night, by the way, and I ran into a guy, an attorney, and his wife. This attorney used to work with Johnny Cochran. He's a great criminal attorney.
Is he Richard? His name is Richard?
No. No. But we're mentioning Johnny Cochran, and he used to work with Johnny. He's a great criminal attorney. Anyway, so do you understand that now, what I'm saying? So you're criticizing someone, and I'm not saying that criticism is misplaced.
I'm not criticizing the parent. I'm criticizing the attorney.
Right. But because you have an expectation that you don't like their strategy.
They
It
say
is.
one thing and
Well,
they do another. See, I
no, no,
don't
no,
trust
no,
the
no, no.
court-appointed attorneys, and
But
you know
listen,
exactly why.
listen. The guy or gal gave her a strategy. Did he not? You don't like the strategy.
I
I
don't
don't like
trust
the
them.
I don't. I don't like the strategy.
Mhm,
But it's a strategy,
mhm.
and unfortunately, with a court-appointed attorney, that's all she's entitled to.
Okay. All right. We're going to leave it at that. Mr.
Okay.
Davis, Margaret King asked, have you ever subpoenaed and cross-examined at the reporting party, meaning
Have
the
I?
person
Have I?
that reported the allegations?
Have I ever? Yes. Do I always? No. One of the first rules of trial advocacy is never subpoena a witness excuse me, who is going to testify against you. And if you think about it, it kind of makes sense. If you know the guy or gal is going to come in and say ABC against you, why bring them to court? Because these cases aren't Perry Mason moments. You know, the guy isn't going to get up there and say, "Oh, I lied. I'm sorry." He's going to continue the lie. And it's not going to be a Perry Mason moment where your lawyer, Vince Davis, is going to make him crack on the witness stand. He's going to continue the lie. Why bring them to court to repeat the lie for the judge to hear again and again and again?
Okay.
By
Brittany,
the way, I didn't make that rule of trial advocacy, right? It's one of the rules. It's like one of the 10 commandments. Don't subpoena in a witness that's going to testify against you. Go ahead.
Brittany, you can get a hold of me. You can call the office, the 888 number on the screen. Ask for me, or you can just ask for me, or you can email me at gat@vincentwdavis.com. Megan, yes, and what if the okay? Tanya Kelly, hi Tanya. It says, what she said, what if the person who conducts the parenting capacity assessment was bought and sold by CPS to make a bad report and is based on lies?
Well, first of all, you got to have evidence of the bought and sold. And it has to be more than your gut level feeling. Do you have evidence of the money transaction? Probably not. So you got to have more than just a feeling. And if you don't have the evidence of the money transaction exchanging hands, you're going to have to come up with a different strategy.
Social workers do threaten, doctors, nurses, reporters.
Let me repeat this. If you don't have evidence of it, you're going to have to come up with a different strategy.
Okay. Megan Wilson wants to know if you have no family, and some people really do not have, a lot of parents do not have family, especially since she said, I grew up in a system at 5 years old. The only family I had passed away, and that was my grandmother. So basically, what if they have no family and friends around, and they grew up in a system, and you still have to fight the system for your children, and there's no 25 names of family and friends to provide to the court?
Okay, what she says, she has no family. She didn't say, I have no friends.
Oh, okay. Well,
There we go, reading between the lines again.
shut up. I'm not.
What if you truly have no family? Well, that really means no family and friends. Okay, I get it.
Betty asked, what do you charge to be an attorney for someone? It depends, Betty. I will answer that, but correct me if I'm
Betty, if you're a friend of Miss G, it's $1 million.
wrong. Betty, it depends on the situation. It depends on the state and county your case is in. If Attorney Davis has to drive. If he has to travel, of course, we put that into consideration as well. But it also depends on how far your case is in the system. Meaning, if it's been open for 2 years, or 1 year, 2 years, 18 months, we don't know. So you would need to discuss that with Attorney Davis or myself. You're more than welcome to call the office and ask for me, or you can email me at gat@vincentwdavis.com. Tanya asked, how can a parent not be allowed in the courtroom when there is a hearing to terminate parental rights? And do I have any recourse of action if it's been 20 years? I'm so sorry, Tanya.
Well, the first part of the question is, excuse me, I don't think that's possible. I mean, if they're terminating your parental rights, you have a constitutional right to be in the courtroom, to offer evidence, to make arguments. But unfortunately, if it's been 20 years and you haven't done anything, something called the statute of limitations may have run and you may not do anything. I mean, it's too late to do anything. However, there is an escape clause like everything else in the law. There is something called a writ of quantum nobis. And that exists in most states, I think. But you can file that. Excuse me. The last time I remember being involved in something like this, I think something had gone by, maybe it was a long time ago, but I think it was like 30 years. But it basically said something happened a long, long time ago. The statute has run, and it's just patently unfair what had happened to me. And I would like the court to, in all fairness, go back and revisit and review this and, right the wrong. Now, that doesn't mean that it's going to be righted, but it does mean that you have a chance to right the wrong. So your state, wherever you are, may have something similar. So you may want to talk to a lawyer in your state about a writ of quantum nobis or the like tool in your state to try to file. But by the way, if it happened 20 years ago, your kids are now adults, right? So maybe I hope you have contact with them, or maybe you can get, an investigator try to track them down, to try to reconnect with them. Okay.
I know it's been going on for a while. It's an hour and 23 minutes. But I don't know. Every time I do the show with you, I can't stop. Tanya Kelly, guys, I'm going to answer this. I'm going to have Davis respond to this. And then tomorrow, God willing, you guys can write more questions. Okay. Tanya Kelly said they terminated my parental rights with my other daughter due to a previous termination, meaning that, you know what that means, right? I had a camera playing when they had 10 police officers and 2 CPS workers coming in my house at 10 p.m. at night. They arrested me and took my daughter. I got out of jail the next morning and the police had seized my computer and camera. The warrant wasn't even signed until the day after at 5 p.m. At 5 in the morning, police eventually gave me back my computer and camera, and they erased the footage of them attack, meaning they erased the footage that was on the computer.
What's the question?
I guess I thought there was more. I guess none. Oh, here she is. Okay, here we go. They did this because I made so many complaints about the supervisor and worker of CPS. They retaliated by basically ambushing her but I don't know where the question is. I don't think there is a question. She just said it happened. Okay, so I guess my thing is, Vincent, when they have no order to do what they did, but then the order is signed the following day, what should parents do about that?
Get a civil rights attorney, bring a lawsuit. It's a violation of the Fourth Amendment when they take your child and break into your home without a court order. The fact that it was signed the day after is the best evidence that they violated your Fourth Amendment rights.
That's good.
And in
Now,
that particular case, you can sue CPS and the police. You were asking me about that earlier, about suing, CPS and the police, or not suing the police.
right,
That is a case where you should be suing CPS and the police.
makes sense. Okay, you guys heard it. I'm sorry I didn't get to all your questions, but there's a few that I left off. But today was an hour and now 25 minutes. Thank you for being patient with me, Attorney Davis. And for those of you guys that's like joining the show, I want you guys, if you want Attorney Vincent Davis to review your court paperwork, right? Or, book a private consultation for him to go over it with you. You can do it by Zoom. You can do it 30 minutes. You can do it an hour. I recommend an hour because I've heard people actually tell me, parents, that 30 minutes was not enough. Okay. You can also, if you're in California or Los Angeles County, you are more than welcome to go to the office. I know oftentimes you guys tell me that the office address, the old office address is still on there. But the new address is 440 East Huntington Drive, Suite 100, Arcadia, California. And also don't forget to join Fight CPS School for weekly coaching, strategy, tools, and more. Okay. And Attorney Davis can coach you on your case for you to handle your case with your court appointed attorney, or you can hire him to represent you fully in court. Okay. If you guys have any more questions, don't hesitate to call me at work, which is 888-888-6582, and ask for me, or you can email me at gat@vincentwdavis.com. Okay. Is there anything you want to say, Attorney Davis?
No, we'll just see everyone tomorrow at 6:30 a.m. Pacific Standard Time, and stay safe today. Are you joining me tomorrow, Ms. G?
Yes, God willing. Yeah.
God willing, doesn't sound too definite.
Okay, I will join you, but what if God forbid something happens to me? What do you?
We mean something like you don't wake up? Okay, I get it.
No, that's not what I meant.
Everyone, I'll see you guys tomorrow at 6:30.
I'll
Whether
see
Ms.
you tomorrow.
G joins us, that will be whether she wakes up or not. All right.
Bye.
See you later.
Bye.
I went through 9 months of hell in trial, and Vince was fantastic in the courtroom. This is a trial attorney. This is someone that you just go and look pretty and sit there and let him do all the work. And we prevailed. 9 months of not knowing. But when you have Vincent W. Davis on your side, you feel comfortable and at ease because you know he's doing the best he can do for you. And I highly recommend him and his staff, because there was never a time where I couldn't call and say, I need help, or I'm feeling this way. I was always able to talk to someone. Now that I have my child back, God bless you, Vincent W. Davis.